I'd like to invite the first session. GDPR's effects on emerging technologies and data-driven economy. So I might terribly mispronounce the names, but I'd like to invite Kyung-Sung Park from Korea University Law School, UpNet Korea, Thomas Strutt from American University, Jan Sozar from SN Attorney Partnership, and Won Young-jo from 11.com, with the moderation of Emre Bayamlıoğlu from Tilburg University.
In this opening session, we're going to have a kind of overview, and looking at the composition of the panel, maybe it's a bit of an outsider's view to GDPR in terms of effects on emerging technologies. We have a diverse panel, and Kyung-Sung Park will start with some enforcement issues with GDPR. On my right side, Thomas Strutt, though he's from American University, he's one from us, one from the Institute. And from the practical legal practice domain, we have Jan Sozar from Essen Law Firm. And finally, from the online retailing perspective, we have Won Young-jo and the floor is yours.
So I'm supposed to talk about the effect of data protection laws, including GDPR, on emerging technologies. And one important emerging technology, of course, is AI. So I'm going to talk about that a little bit. And then I'm going to talk about its impact on big data in general. Of course, AI depends a lot of the supply of big data that's used to train AI. So they're both related, but I'm going to take it apart and start with a discussion on the impact on AI. Now, people are worried about the exclusionary effects of AI. There are three instances of exclusion that we can talk about. One is economic exclusion, meaning AI will take away our jobs, and only the companies owning AI will flourish. Other people will be out of jobs. And also, people are concerned about algorithmic exclusion as well, meaning AI, people are worried that AI will intensify our discriminatory behavior or discriminatory tendencies, for instance, in hiring people or granting loans. Will not even make the benevolent mistakes of giving people not worthy of loans so that they have their second chances at their lives. And then there is a third exclusion or exclusionary effect that AI may have on our lives that originates from the fact that AI, the way it is developed now, it is centered around machine learning, which requires a lot of training data. And the companies that have amassed, accumulated a lot of training data are becoming smaller and smaller in number. So there is more and more concentration of the training data on a small number of companies. AI is, as you have seen in the movies, AI is a program. it's like operating software, like Windows, that can respond better, that can respond more like a human being with the input, which means program can be copied, distributed, and Google already have begun open source AI where people can, ordinary people can access AI software. So what will make or break for those wishing to use AI is whether they have access to the proper training data. And that has been, whether what regulation will prevent siloification or I don't know what the term is now, but the act of making the silos of data, holding the data, not making it available to other people, but harvesting all the benefits of the data only for themselves. If we call that siloification, we should think about what regulation will actually prevent siloification of training data. And I think it is on this entry point where GDPR comes in. GDPR, in one sense, will, by making data protection regulation uniform across the countries within EU, may reduce the siloification effects on data. But at the same time, data protection laws can be used as excuses for justify building the silos of data and not making available to other people. And it has, such tendencies have appeared already in other countries that have strong data protection laws, including Korea, where the government, the judiciary has refused to make available judicial decisions databases for the pretext of protecting people's personal data, the personal data of witnesses, parties, although none of the parties or witnesses has claimed to, has petitioned the court to make their data private. So the whole treasure trove of information about people's senses of justice, how disputes are resolved, how resources are allocated. The academicians, companies, governments, they are prevented from harnessing the data there. And that silo, I'm talking about just one silo as an example, the silo of judicial databases, databases of judicial cases, is being used only by judges. So judges have access to all the real name judicial cases, but other people have no way of cross-checking where their decisions are consistent with other cases. So we think, we should make sure that GDPR does not intensify the siloification effects or siloification tendencies of data controllers, such as Korean judiciary. There's a public data controller, but there can be many other private data controllers that will refuse to share their data that will further the benefit for the greater society. Having said that, and I think GDPR leaves a lot of room for interpretation. Enforcement of GDPR depends a lot on value judgments, if you read the text. So how we will come out in drawing the line in the spectrum set by each phrase in GDPR. I think it's a very difficult challenge, but it's a very important challenge for the future of emerging technologies like AI and what it can do for the society. There's one aspect, well, there are many other aspects, but there are one aspect that we can be assured, which is pseudonymize the data. What GDPR does, I mean, a lot of companies have generated myth, as some of the keynote speakers said, myth and horror stories about GDPR, and yet what GDPR does is it creates this new concept of pseudonymized data, and it encourages companies, encourages all data controllers to pseudonymize data, and then in return give benefits for using the data in pseudonymized way. For instance, pseudonymized data can be used for a purpose that's different from the original purpose of collection. It cannot be completely different, but it can be used for a purpose that's quote-unquote compatible with the original purpose. What we will mean by the compatible purpose, how broad the circle of compatibility we recognize, I think is a key in making sure that GDPR makes the big data, the databases, available for the greater good of the society. And also, pseudonymized data can be used for historical, statistical, and I forgot the third one, the other public interest purposes. So this new concept of pseudonymous data is very important for big data, because big data means, big data, the keys to big data is 3 V's, right? Velocity, volume, and variety. Means diverse databases are linked to one another. So for instance, one's library rental records are somehow linked to that person's health records. And when you amass the linked data on many people, you can come out with things like whether people reading more books are healthier, or people reading certain books contract certain diseases. Some kind of insights that we didn't know before. That is the promise of the big data. Now, for big data to happen, these databases should be linked to one another. When the databases are linked, the entry for one person in one database have to be matched to the entry in the other base of the same person. But when you do that, the only way to do that without identifying the person, without having the data pick up identifiability, is pseudonymization. So pseudonymize both databases using the same algorithm, same formula, and then match the same pseudonyms. Now, GDPR, in a way, has opened the legal possibility, kind of the clear way in which database can be linked and be harnessed for big data. So I think that's that's a good start, and we'll see how far it goes.
Thank you very much. Thanks a lot for this wonderful opening contribution. Thomas?
Yes, definitely. I should have slides over there. All right. Oh, cool. So I'm Thomas Stewart. I actually used to work for the IT Law Institute here in Istanbul, working for Localization, and I thank her very much for inviting me here. I am now at American University in their communications department as a student. And today I'm going to be talking about cross-border personal data transfers and the data-driven economy, specifically looking more at GDPR and their adequacy decisions. So in this globalizing world where data is everything now, cross-border data flows have grown 45 times from 2005 to 2016, according to the McKinsey Global Institute. And they're expected to grow another 9 times over the 5 years from 2016 to 2021. And it's estimated that 80% of commercial data is personal data. So it really shows this interconnection between personal data and these global flows of cross-border data flows. And it shows that this turns into these increasing challenges and concerns when it comes to respect for privacy. And a lot of countries are finally realizing this. I think over 100 countries now have some form of privacy law. And it's important for many reasons. Studies show that it can help sustainable economic growth. It also, when consumers know that privacy protections are in place, it can increase trust and confidence, which can actually be a net gain. And of course, privacy is also helpful in respecting human rights and promoting the social good. So to the extreme of these privacy protections, especially after the Snowden revelations in 2013, a lot of nations started their own national cloud computing strategies and thinking about implementing data localization laws. Russia and China are 2 of the most notable. You also have other countries like Vietnam, Nigeria, Kazakhstan, Indonesia that create these laws that basically just say that data has to stay within the country where the citizen lives. But bringing this back to the GDPR, not trying to make the connection that this is some form of data localization law like we've heard during the keynote, but it does restrict the transfer of data without safety guards in place. And basically the first would be these adequacy decisions where another country would be examined for their human rights and privacy laws and whether they're essentially equivalent to the law to the GDPR. And then if that's not the case, then organizations can use these additional safeguards like binding corporate rules or standard contractual clauses along with codes of conduct and certification schemes. And if that's not the case, then you can finally move to these derogations for public interest reasons. So focusing on these adequacy decisions, there's currently 12 countries that have some form of an adequacy decision. Canada has just within their commercial sector, and the US has the privacy shield. And when the original safe harbor framework was invalidated in 2015, it really raised this bar to this new essential equivalence. And as we can see, these adequacy decisions are few and far between, which is really why I want to focus on them, looking at more of the underlying political reasons for adequacy decisions and who is pursued for an adequacy decision. So the European Commission in January 2017 actually kind of gave a hint at how they decide on what countries to pursue for an adequacy decision. And the first is really existing commercial relations with with a third country. And the second would be the extent that there's already these personal data flows going to that country. And the third and fourth reason get more to this these political reasons and these ideas of the Brussels effect or this convergence, where it's looking at how the third country could be a role model within its region to bring these European ideas to that region, and also overall political relationships with that third country. So to look at this, we'll just examine like 3 adequacy decisions. One would be Japan, which is, it's currently not, it's in its final phases. The talks were completed in July, and September 5th, the European Commission announced that they're starting the formal procedures to adopt the adequacy decision. South Korea is still in talks for their adequacy decision, and as mentioned again by Ralph, this is the first reciprocal adequacy decision, so both countries would be, or both jurisdictions would be giving adequacy decisions to each other. And with it, notably, Japan will also be adding additional safeguards to any European data transferred to Japan, which we can see here. Some of the things that would accompany this data would be Japanese law doesn't have really the same definition of sensitive data, so they would be adopting this. Also, access rights. Japanese citizens don't have access to their personal data if it will be deleted within 6 months, but this would allow them to access any data. Also, purpose limitation would be brought in, which would basically allow, the third parties would have to comply. They would have to stick to the original purpose at which the data was collected. Also, onward transfers, restricting transfers beyond Japan when EU data comes to Japan. And then also it gets at this idea of pseudonymization, where basically the Japanese definition for anonymously processed information isn't exactly truly anonymous, so it would be adopting this European definition. And it's interesting looking at this like political effect of how the GDPR and these adequacy decisions can bring these rules to new regions, and how the heavy weight of having and the benefits of having an adequacy decision would mean that countries are willing to change and comply and bring in these European laws. And then moving to the United Kingdom, on March 29th, 2019, the United Kingdom will no longer be an adequate country, and they've openly expressed that they, because of them leaving the EU, and they've very openly said that they wish to stay within, to have an adequacy decision and to have a special relationship with the EU, bringing the ICO in for decisions still. But Michael Barnier, the chief negotiator for the EU on Brexit, has basically said that this will not be the case, and that the UK has to just pursue a regular adequacy decision. But since these take time, there is this worry that an adequacy decision won't be made before March, so that this will change, and a lot of countries or a lot of organizations within UK will have to deal with this. And then there's also the worry that the UK might not even be considered adequate because of some laws within the UK, like the Investigatory Powers Act of 2016, which allows for pretty broad surveillance. Also looking at the UK won't incorporate the Charter of Fundamental Rights, which is the basis for the GDPR, and also the UK Data Protection Act of 2018, which is almost a copy of the GDPR, does have some exceptions, like for immigration data, and this could be a big deal for not being deemed adequate by the Commission, even if they want to. And then lastly, there's also the US-EU Privacy Shield framework. It's up for its second annual review, and there's lots of comments that this might be the last one because of a lot of developments within the US. There was the Cloud Act passed, which would could allow other countries to access personal data within the United States and transfer it back to the country for warrants. Also, FISA's Section 702 was reauthorized, although bulk collection surveillance that was used under Section 702 did stop. The reauthorization didn't apply any additional safeguards, so it is possible that this bulk surveillance could start again. Also, the Privacy and Civil Liberties Oversight Board still has 4 vacancies in the United States, so they're delaying reports on a lot of things, which is a big part of, like, they oversight, or they overlook basically government surveillance within the United States. Also, the Privacy Shield ombudsperson is still unappointed, and also long-standing issues with the Privacy Shield framework is that the FTC is still they're the ones basically enforcing this, and they're only enforcing it under the FTC Act, Section 5, which isn't really about privacy, but more about consumer protections. And there's also no comprehensive federal law in the United States currently, although the White House is currently actually asking for comments about developing a new federal privacy law for the United States, although a lot of people criticize that it's just tech companies pursuing this to preempt state laws that are much stricter, like the new California law. And one other point I'd like to get at is the possibility of how trade agreements also factor into this idea of these cross-border data flows. Under the WTO General Agreement on Trade, there are these carve-outs for specific public policy pursuance, or that nations can pursue, like for public health or national security or public morals. And the USMCA, the United States-Mexico-Canada agreement that just came out, which pretty much copies verbatim from the Trans-Pacific Partnership, bans data localization. It also requires each party to adopt some form of privacy protections, and it recognizes specifically the importance of limitations on collection, choice, data quality, purpose specification, use limitations, security safeguards, and accountability. It also doesn't allow for forced technology transfers like source code, although it does allow for judicial authorities and regulatory bodies to investigate source code. And then along with this, also trade agreements that the EU has pursued, like with Canada and Japan, they have provisions for protecting privacy while keeping an adequacy carve-out so that they could invalidate a adequacy decision that they have with a trade agreement partner, and it wouldn't violate the agreement. So basically, in sum, cross-border data transfers are extremely important for the internet, and without them, there is this idea that each nation imposes its own laws, and there's this possibility for this fragmentation. And right now, the leading privacy law is the GDPR, and a lot of countries are willing to converge towards this European data law so that they can effectively enter this market much more easier and with full compliance. So, thank you.
Yeah, thank you, Thomas, for this comprehensive global overview. And now from the practical domain, we have Can Sözer from Essen Law Firm.
I also have a presentation, but if it's available on the computer.
The lawyer's view.
Hi, everyone. My name is Can Sözer. I'm working as a senior associate and also the head of ITC in Essen Attorney Partnership, Baker McKenzie Istanbul office. This session is quite interesting. I'm going to give you a little bit of practical legal impressions of GDPR's territorial scope and how we can work it out in a practical sense. Very fast, I will speak about ways to comply with GDPR. I will give you some hints about the most frequently asked questions to lawyers these days about GDPR and give you some top tips from a practical perspective, because I know that some of you are representatives of private sector companies, so this may be of use for you. So let's talk about the ways to comply with GDPR. I thought about this before I came here, and I could come up with 4 practical ways to comply with GDPR. The first one would be a GDPR impact assessment, which was also spoken about prior to this session by some academicians. The second way would be GDPR compliance of Turkish entities, which means companies which are established in Turkey. The third way would be a GDPR compliance program for EU subsidiaries of a Turkish entity, which means companies who are established in Turkey but having minor subsidiaries within the European Union territory. And the fourth would be a GDPR localization project for a Turkish entity, which means a company established in Turkey. So, I will speak about from a practical perspective, but first look at the in-territorial and extraterritorial scope of GDPR. In-territorial scope would be, we would have a data processor or a data controller within the EU, which processes data subjects' personal data, regardless of whether processing takes place in the EU. That would be an in-territorial scope of GDPR. And the extraterritorial scope would be having 2 criteria, actually. The first criterion is offering goods or services to data subjects in EU, regardless of whether payment is required. So this may also include Turkish companies. This is why this is important. And second criterion is monitoring behavior of data subjects within the EU, regardless of whether it takes place in the EU. So we have 2 criteria, right? So let's look at the details of this. In order to assess whether a company is under the scope of the GDPR, first of all companies have to conduct a GDPR impact assessment. And as a result, you may come up with the conclusion that your Turkish company is actually subject to the GDPR. This may be possible. And this would be an extraterritorial scope. If we talk about the criterion number 1, for example, we can talk about e-commerce websites or retail companies, right? So there may be a e-commerce company established in Turkey, but it may be open for sale to persons who are located in the EU. So this means that we are under the extraterritorial scope of GDPR. Another example would be retail companies. We have very successful fast fashion retail companies who are actively operating in the EU. These are Turkish companies, but they have branches in the EU. They have distributors in the EU. They have stores in the EU. This may be possible. The second criterion may have a lot of examples. For example, we may think about a Turkish website, Turkish application, a Turkish system, a Turkish database that monitors a wellness data, a fitness data, a health data of persons who are located in the EU. And this data may be, for example, collected through wearable devices, smart devices. There may be location tracking via mobile apps, for example. So location tracking is also criterion 2 under the extraterritorial scope of GDPR. And there may be also online behavior-based advertising. So we may have a Turkish company, but we may be monitoring online behavior of people who are located in the EU, and we may be doing advertising to those people. So this is also extraterritorial scope. So once we define that we have we are subject to the GDPR. What should we do? Let's come up with an example of an e-commerce website open to data subjects in the EU. So there may be many things to do. There may be a legal due diligence, there may be an IT due diligence, but from a legal due diligence perspective, there may be certain practical steps. This is not a comprehensive list. This is just a few steps to start with. For example, review of terms of service and privacy policy online. Review content on the website regarding collecting consumer data, such as forms, disclaimers, warnings, anything that pops up on the screen of the data subject in the EU. Analysis whether a DPO, a data privacy officer, and or a representative in the EU is required for this Turkish company. This may be also a practical step, but this is only a legal due diligence, and this is only a good start. So, if we talk about GDPR compliance of EU subsidiaries of a Turkish entity, as I said, there may be a Turkish company established in Turkey, but having subsidiaries within the European Union territory. So let's take an example of a retail company. This may be an electronics company, this may be a fashion company, which have stores, corners in the EU that sell to data subjects in the EU. So we can think about several steps to start with in order for us to be compliant with the GDPR. For example, preparation of data inventory. Which data do I have in my company? Which data do I collect from data subjects? The retention periods. Preparation of required policies and procedures. There may be internal policies and procedures. There may be external policies and procedures. Customer-facing policies, employee-facing policies, IT security policies. I need to prepare these to be compliant with the GDPR. Preparation of intra-group data transfer agreements and or binding corporate rules. These are possible under the GDPR. I may be transferring certain personal data of data subjects in the EU to my Turkish company in Turkey. So there's a cross-border data transfer. And in order to ensure that I do it compliant with the GDPR, I should have an intra-group data transfer, or I may have a binding corporate rules. So these are some practical steps to start to a legal due diligence. So the fourth way is GDPR localization for Turkish entities. I may have a Turkish company, but I may be a part of a global structure. I may have a global holding. So there may be certain GDPR compliance initiatives on the top. I may benefit from them as a Turkish company. I may have them localized and translated into Turkish. The data inventory, the policies and procedures, and intra-group data transfer agreements. And maybe see whether these documents are in line with my own national data protection law, such as KVKK. So let's move on to frequently asked questions. We have a lot of questions from clients these days, and we run a lot of GDPR compliance projects, but there's a certain misunderstanding about GDPR and the relationship of GDPR and KVKK. Should our company run a GDPR compliance program? That depends on your GDPR impact assessment. First of all, you should run a GDPR impact assessment to see whether your company is actually under the scope of the GDPR. When should we run a GDPR impact assessment? You have to run it now. You have to run it today, immediately. Our company completed a KVKK compliance program, a Turkish data protection law compliance program. Should we also run a GDPR compliance program? KVKK compliance isn't the same as GDPR compliance. KVKK is based on the EU Directive 96, but it's not completely the same as GDPR. So these are different. So you should also run a GDPR compliance program if your GDPR impact assessment says so. Our company completed a GDPR compliance program. Are we also KVKK compliant now? No. Again, these are two different things. Turkish data protection law may have its own specialties, so you have to look at it from a Turkish law perspective as well. Is legal compliance sufficient for our company? Again, no. You also have to have an IT compliance as well. Legal due diligence, legal compliance is only one aspect. You also have to have a certain antivirus programs, certain firewalls, certain IT security measures, necessary softwares, necessary hardwares to ensure that there is no data leakage. Our company completed a GDPR compliance program. Will we receive any data subject complaints at all? Completing a GDPR compliance program, completing a KVKK compliance program doesn't necessarily mean that you will not get any data subject complaints at all. You will get tons of them. And you can also get certain notifications and information requests from the Turkish DPA as well. So what are our top tips? Run a GDPR impact assessment now. This is very crucial. Appoint someone responsible from GDPR compliance. If you are working in a private sector company, you have to have someone internally that is responsible from internal management of know-how, internal management of information from a legal perspective, from an IT perspective. You have to have someone that will follow up with the GDPR compliance. Run mandatory trainings for GDPR awareness. That also is applicable to KVKK awareness. You have to have at least a year, or ideally twice a year, training for your employees. Run both legal and IT compliance programs. One is not sufficient. Having a legal compliance, having a legal due diligence program completed is not sufficient. You should also run an IT due diligence program. Benchmark what competitors did. This is very practical. This may not be sufficient all the time, but look at your competitors. Look what they do on the market. Look at their websites. Look at their customer-facing documents, their privacy policies that are available online, and get an idea. This is the end of my presentation. Thank you very much.
Thanks for Can Sözer for this practical view. And now we have our final speaker. You have a presentation? Oh, okay.
Even though I'm not going to present on the screen, but would it be better to stand up and say something? My name is Won Young-jo from neonbiru.com. It's okay. It seems that this company will make a lot of money from now on. If I may introduce our company, this company was set up in 2012 and then started e-commerce in 2013. Maybe most of you are very familiar with our company. Now we have 13 million members, and we have a monthly 1.4 million transactions. Within 5 years, we have grown so fast. And then I met this agenda, the Turkish private personal data protection law, and then the enforcement of the GDPR in this year. Actually, I was there. I had a chance to join in Brussels to get to know the GDPR more. For the company, this is kind of very important and then crucial environment, especially not only as a complying issue, but also because e-commerce is, we are surviving on the basis of the trust of the people. So this is very important to us. it might be helpful to, referring to some Korean practice as well, because I'm Korean, and then I was in charge of the digital music services in Korea in 2004, which is named as a Melon. From that time, the Korean government, actually the parliament drafted the personal data protection, and it took 7 years for that law to be enacted. So in 2011, it was enacted. Through my since then, most of my career was working in the online service area. If I remember the practice of the Korean government at that time, throughout the nearby the Korea, there are a lot of ecosystem predators, who is always trying for the chance, to get the data and then convert it to kind of voice phishing or to utilize it as another undesirable area. So this is not just kind of beautiful legal terms, creating, but it was actual life, and then some of the companies were indicted and then get some huge penalty, and also it was kind of still up to now very crucial social and then political problem. The good thing I remember from the Korean government was they set up the, it was not just checking and filtering, and not just announcing the laws, but also supporting the industry such as by having some certification program, and even though it's not the omnicure things, but at least it was giving us some guidance for the companies. Well, as a personnel, as an individual, we might experience this, the personal data protection issues, but in the company, this is not the easy things. The current mother company is not a big company, but it has like 40 members of the team members inside, but also have another specialized company as an outsourcer. So to cope with the technical methodology, also the administrative methodologies, and then let's say it's not that easy for the company to compose that organization and then to find some talent all the time. So I think in terms of the government support, it's very important to help the industry not to be shrunken by this regulation. So that was a good part. Also, regarding the GDPR, I think Korean government is still in helping the not only the big enterprise like SK, Samsung, Hyundai, but also the small and medium-sized companies as well. For our company, N11.com, in my memory, the Turkish data protection law was enacted 2016 April, right? And then from that time, I think we did many things in terms of organizational things, and then diagnosing, and then bring the manuals and then other practices from Korea, and then also in this year, we also had a kind of impact assessment, not the GDPR assessment, but a different one. The thing we found is to do this is kind of changing the whole blood, the whole, the ecosystem inside. It's not a simple thing. I'd like to, mention several considerations through our, several years practices. Definitely, first one is data protection is very important because it is providing the trust, and then it is protecting the general public. Second one, but it's going to take some time. The Korean case, they drafted the law 2004 and they enacted 2011, taking 7 years, and then because the law was also evolved by the ecosystems, have changed. It's not just expressing some ideal type of the protection status. So we should be a bit careful and patient, and we have to take care. Second one is not only the data protection, but actually in terms of ecosystem, the whole IT security is more important, especially for this country. The other day there was a news that Facebook and there was a hacking for the Facebook to steal something. That the big companies, even that global, the big giant, the big dinosaurs, having those kind of things. The thing is, nowadays there is no single standalone company. Our informations, our services, everything is interdependently connected with each other. Let's say about the big data service. Well, Google is providing the big data service as a solution, but it is on the cloud. It is not existing on our company's premises. Oracle is not providing anymore, some new models for the servers. It should be the cloud services, which means, like it or not, if we want to use that service, we should subscribe that services, as we subscribe the Spotify or something. So it is very important for us to follow up everything, and then it is also impossible and difficult for us to follow up everything. My point is, it takes time, but there should be some, let's say, everybody mentioned about the importance and then the crucial importance of the GDPR, but let's say there are only in Istanbul 400,000 of SMEs are there, and then let's say a lot of companies are there. How much we going to comply all these? I think there should be some role from the government side to create and then support the things, such as like a certification program, even though it might not be perfect, but it's very crucial to this society. And then it's not just a beauty to follow, try to follow all the things. Third one is about the consideration about, in my memory, we are the only company who has been following up this issue from the right beginning in 2016, the April of 2016 in Turkey. The other companies, I'm not sure that how much they are wondering, even though there was some competitor benchmarking. So my suggestion to this, because I was in Korea and then Indonesia for 6.5 years, and now I've been approaching to the 4 years. Instead of trying to copy and then do all the things right away, we gotta see the real, actual legal interest that should be protected, and then proportionately we need to prepare these things. That is my idea. And then also for the country, we have been having some difficulties to recruit some expertise from our side. Because let's say compliance manager is very weird and then difficult job title in Turkey. If we are giving the job title as a compliance manager, we are not going to hear any news from the recruiting company. We have to change the name. And then also, the harmonization inside the organization, IT, legal, and the risk management. We set up the risk management internally. And then there is a tendency that, the guys try to avoid this job. But I think this is a kind of special industry to build in this country, because IT security business, like it or not, because we are living in more and more, exponentially connected each other on the internet-based society, it is very crucial. So I've told this many times to Professor Leila Hoja. It's an opportunity for the Turkey to bring up the IT security industry, not only the data privacy, but a lot of things. Yeah. So, but finally, among all the things to preserve, one last thing. In the regulation side, also, I think we need to rearrange. For instance, about the deletion of the data, removal of the data. The civil law is saying you can remove it 1 year after. The commercial law is saying that, okay, you need to preserve it, let's say, 3 to 5 years. But the other law is saying that more than 10 years. So, for the effective and efficient implementation for this agenda, and then to be, to make this regulation gotta be more natural, there are many things to consider together. But as a company CEO of the N11, I will promise that we're gonna do all the best to be loved and to be trusted by the Turkish citizens. Thank you.
Thank you, Youngjo, for this valuable contribution from a retailer's perspective in a foreign land. So, having completed panelists, I think this is the session for question and answers. We still have time. So, any volunteers? I guess they will extend you a microphone. Will they? They will.
Hello, thank you for all the great presentations to gentlemen. I'm a Turkish qualified lawyer working with data protection and GDPR issues. And I would like to ask a simple question especially to the gentlemen who addressed GDPR during their presentations. What do you think about the Article 3 extraterritorial effect of GDPR, but its enforcement during a breach? If a breach happens in Turkey with a company that has no legal location in Europe, how the enforcement of the GDPR will take place?
I took myself responsible for this question. Well, there is no definite answer to that. I mean, even the European Union doesn't know how to apply this. But there is a global trend, which also Turkey follows, that countries are trying to apply their own laws upon foreign companies more and more each and every year. I mean, in Turkey as well, Turkish Competition Authority did this. Turkish Tax Authority is doing this, is doing investigations on offshore companies like Facebook and Apple and Google. I mean, there are some examples in other countries as well, including the European Union. So I don't think that there's a definite answer to that, but I don't think that it's impossible. And I'm sure that European Union will find a way to apply this.
Just a follow up. One of the practical constraints on extraterritorial application is, well, okay, let me start the sentence different way. Extraterritoriality is a lot of times limited by the practical constraints in enforcement. So if that company that committed the breach doesn't have any legal entity, doesn't have any asset inside the country, or does not have any registration or business license within Turkey, even if the regulatory bodies within Turkey want to do something about it, there is no target, I mean, there is no leverage it has. So that happens to a lot of other countries as well. So Korean regulatory bodies practically do not have any leverage, practical leverage on, for instance, Google and Facebook, which only have liaison offices inside the Korea that do not generate revenues and don't have servers inside. So practically they are practically out of the reach of regulation. Therefore, they are legally out of reach of enforcement.
Yeah, we have another question. Actually, I can't see well because the audience is all in the dark, so.
Thank you. Sorry for asking too many questions. I'm excited about this topic. There's an area that we often forget about, and that's the data of people who have died. Accumulated over years, emails, everything, and all other data. And this is provoked by your question that some laws say you can keep it for 1 year, others is 5 years, others 7 years. What does the GDPR provide for data of people who are dead, or do their rights die upon their death?
A person who has died,
Mm-hmm.
whether GDPR applies to a data subject that has died.
Well, first, we have to find out who yeah.
Well, it's a very interesting question. Well, a person who is dead is actually it will not be possible for him or her to enforce his or her rights towards any kind of data processor or data controller that is in infringement of data protection rules that are under the GDPR. So this is, at least in Turkish law, in any continental law, this is a right, this is a personal right that is attached to that person very tightly. So that person will not be entitled to enforce his or her rights. And these kind of rights are also usually, in many jurisdictions, are not inheritable. So that will not be practical as well from that perspective. But of course, I mean, I'm not, GDPR has to be looked at in that sense, but at least in some other jurisdictions, there are also certain other national provisions that enable certain measures towards protecting one's data after that person is deceased, to a certain extent at least, from a private right to privacy perspective, right to private life perspective, and protection of personal rights perspective. But this would not be probably the main concern of GDPR, as far as I think.
Uh, I can make my answer very easily. Korean law is the same. But at the same time, there are times that survivors of the defunct data subject have a dire need for the information that's inside the person's email accounts, things like that. For those on a case-by cases, the courts have ordered the data controllers, email service providers, to open up the email contents and provide for administration of justice.
It might be a good time to close the session, also for time compliance purposes, though I'm still, the audience is in the dark, I can't see very well, but I think we don't have any more questions, I guess. Okay. I deeply thank to all our panelists for their contributions, and I guess it's coffee break.